It's Monday, October 25, 1999. We're in Los Angeles, California. Federal Court. The Honorable Gary Fees has issued a tentative ruling strongly in favor of Roy Bauer, the author of Dissent, a newsletter that has harshly criticized administrators and union leaders of the South Orange County Community College District, where Bauer teaches philosophy. The district claims that Bauer's writings violate the district's workplace violence policy. It has ordered Bauer to tone down his newsletter. Mr. Lisson is representing the district. He hopes to persuade Judge Fees to change his ruling.
Your Honor, one must consider the facts.
The facts? Well, Mr. Lisson, I don't think that the factual record is terribly in dispute. And, as I've noted, you try to add lots of things after the fact to build up the record. But the bottom line is that Professor Bauer was going to be disciplined for what he wrote in his newsletter called Dissent. The publication strikes me as being so plainly protected under the First Amendment that it's hard for me to understand what the administration was thinking when they decided to make a public fight over this issue.
Well, Your Honor, I think that you have to put it into context. You have to recognize that these statements on the part of Professor Bauer had a definite and debilitating impact on the organization. For example, in November of 1997, the president of his college, Dr. Mather, specifically directed Bauer to assist in creating a positive environment on the campus. He has violated that directive, and, as a result of these negative and critical publications, he has seriously undermined the accreditation of the organization itself. The impact of Bauer's speech has been disruptive of the organization. You have people at the two colleges that have stated that they are unwilling to get involved.
You're talking about the speech which is in the written material, in Bauer's publications. Is that right?
That's correct, Your Honor. You have Sherry Miller White saying that, out of fear, she won't participate in activities.
And is that because she thinks that Bauer has got an enormous crane and he's going to take this so-called granite slab and actually drop it on her head? Or is it because she thinks she's going to be criticized?
You know, I think it's because, Your Honor, she feels physically threatened for her safety. Now, the crane.
Wait a minute. Wait. If she feels physically threatened for her safety as a result of Bauer's satirical writing, the stuff about the 2-ton slab of granite that he hopes to drop on President Mather's head, aren't we saying what we're going to take the most sensitive, the most fearful, most concerned person's standard, and say, well, if you offend them and they are fearful, then we therefore can muzzle the speaker?
Well, Your Honor, I submit to you that, in the Lovell case down in Poway, when that student threatened the counselor, she did not have a gun on her. She did not have any way of immediately carrying out the threat.
That was face-to-face, wasn't it?
Yes.
It was a face-to-face threat. It was not a written publication discussing issues of public concern.
But Professor Bauer has been involved in face-to-face threats. The written publications are merely an extension of those face-to-face threats.
That was never a basis which was given in 1998, when this whole thing started. Nothing of the kind was mentioned. Clearly, you are engaging in an after-the-fact attempt to shore up what was a plainly inadequate basis for disciplining Bauer. Even if you take into account this so-called threat to the vice president. What was it? Bauer said, "You going down." That's a kind of street talk. It just means that, when this administration fails, you going down with it. Now, I don't think anybody would interpret that Mr. Bauer was going to engage in violence, based only on that. Do you have some evidence that Mr. Bauer actually, in fact, on any occasion, has assaulted anyone?
Well, no. He once told someone, "You fucking asshole."
You fucking asshole. If that's an assault, then the courts would be filled to overflowing. I've actually heard that remark in the courtroom directed at somebody in a black robe.
But, Your Honor, Bauer's actions are a clear insubordinate violation of a direction that was given by President Mather. And it was an attack upon President Mather.
You mean the direction to, quote, make things nicer, make the atmosphere more harmonious, be positive? Is that the directive that you're talking about?
That's it in essence.
Maybe the directive is a First Amendment violation by itself. To say that to a tenured professor of a college. I mean, look, this is a college campus. If people can't speak their minds on college campuses, I don't know where they can speak their minds. It is supposed to be the bastion of free speech and discussion. The administration is attempting to portray the problems that exist at the colleges as problems which can be funneled through their lens and laid right at Mr. Bauer's doorstep. But the record plainly won't support that. This is a community that has all sorts of disruptions for all sorts of reasons. And Mr. Bauer may not be behaving in the most civil fashion. He may be making jokes and engaging in satire that some people might characterize as adolescent or whatever, but it doesn't seem to me that that's the sort of thing that he ought to be disciplined for, especially in this context.
Your Honor, I think the disruption is there. I think that to characterize the fears of these individuals is beyond reason, which I think this court must do to grant a summary judgment, doesn't recognize the significance of the information that's before the court.
Well, if what you're talking about now is what's in Bauer's publications, then, yes, it's beyond reason as a matter of law, in my opinion. Mr. Lessin, I certainly understand your client's unhappiness with Mr. Bauer. The problem is, it just seems to me that unhappiness is not something that may translate into a muzzle. Do you have anything more you want to say?
Yes, Your Honor. I think the signed statements have substantiated the fact that people are not participating in meetings because of Bauer's publications. What you really have here is something much more effective than a sit-in demonstration. If you use fear in keeping people from coming to meetings, then you don't need a sit-in.
Well, if people don't want to come to a meeting because when they come and speak, they're going to be criticized, so be it. That is not a basis for keeping somebody quiet. I understand that a lot of people would like to do business behind closed doors, that they would like to make decisions that they don't have to explain, that they would like to come to conclusions and judgments and issue policy without having anyone present to listen and to understand and therefore to make rational, powerful criticisms of them. If that's what they want, well, that's just too bad. Under our system, one cannot avoid powerful criticisms. And if people are afraid of going to meetings and speaking up because they are going to be the subject of criticism in a publication, well, that's just life under the First Amendment, as far as I can see.
Your Honor, we live in a place and in a climate, unfortunately, where violence is all too prevalent. We live in a community, unfortunately, where people are, quote, going postal. And Bauer used that phrase in his writing. Going postal.
Does that mean that those words should never be spoken?
Those words should not be spoken by an employee about his immediate supervisor.
That is not the context. I've got Bauer's writing in front of me. That piece of writing is referring to a past event in the context of criticizing the self-congratulatory nature of the discussions at that time. In that context, he's saying, quote, no reasonable person could have resisted going postal. That's what it says. I'm not going to argue with you about the seriousness of workplace violence. That goes without saying. I just think this is a case where that concept, a legitimate concept, is being stretched for the purpose of taking a vigorous critic of the administration and the Board of Trustees and trying to keep him quiet. That is how this case hits me.